As always. Joining me now is civil rights attorney Jim DeSimone. We're also going to talk with him about the Derek Chauvin trial. Mr. DeSimone, thank you for joining BNC. With protests happening simultaneously as this trial, talk about the judge's decision not to sequester the jury here. Do you think that was a good idea?
I think it was a good idea. I mean, even if the jury is sequestered, are you going to take away televisions? Are you going to take away their cell phones? I mean, we have access to the world wherever we are right now. So why sequester the jury? It's almost like a bit of a punishment for them. But sequestering them through the deliberations makes sense. And I think Judge Cahill, as he's done throughout this trial, has found the right balance.
Now that the defense and prosecution have both rested their case, who do you think most effectively presented their case to jurors?
Well, I'm with Dr. Laura McNeil, who just commented on that. I mean, I think the prosecution did an amazing job with their array of witnesses in pounding home that you can believe your eyes here, that Derek Chauvin's knee on George Floyd's neck was the cause of his death, and you could see his life slipping away from him on that video. And I thought when Dr. Tobin pointed to the time when you could see his life leaving the body, it was just a moment that I feel chills right now thinking about that. So the prosecution really nailed it down, again, having all the people from the Hennepin County and police force and basically testifying, the chief of police, Lieutenant Zimmerman, when he said it was totally uncalled for and unnecessary to use that force against policy. And then you have compared to the defense, and the defense use of force expert Barry Broad was just, I mean, you know, he didn't come across credible. He didn't come across as knowledgeable. There's no justification for that force. Dr. Fowler, maybe give him, you know, a C- in terms of his testimony, but again, factually, he's undermined in so many ways. Was it pills in his mouth or was it gum? Was the car on or off? Police protocol: you turn your car off when police relate to a scene. That car most likely wasn't on. And most importantly, the pressure on George Floyd's neck, even giving him credit, 35 pounds on a neck with a knee on top of it. Who would choose that as a way to be restrained? I mean, that's a lot of pressure to put on someone's neck. So overall, I think the prosecution made their case, and really what we're looking at, is this going to be murder or is this going to be manslaughter?
And I chuckled a little bit when you said you gave the defense's star witness a C-. What does that say about their case when these are the type of expert witnesses that they have put forth?
Well, it wasn't lost on me either that this doctor hailed from South Africa. He of course, did a stint in Baltimore, and what didn't come out in evidence is that he's been sued for being the medical examiner in Baltimore, for holding that other deaths have been unfounded when the person has been tased and put in a prone position. So but you know, that didn't even come into evidence in this trial. But that is this man's history. And I think it shows the problem that they had with really finding an expert that could justify this. I mean, Barry Broad, the use of force expert, he went to Minneapolis first and said, "Hey, I'll be your expert." They said, "No, we got better than you. We don't need you." And then he went right to to the defense and said, "Well, hire me." And I think it showed that this man was not credible. I think you really lose credibility when you claim that Dr. Fowler is claiming that the force that was on George Floyd's neck, his back, the way his hands were restrained, played no role in his death. And it just doesn't make sense. You know, the defense came out of the box in their opening statement. They said, you know, really use your common sense. And as trial lawyers, we love that, because the notion of common sense is actually in the jury instructions. And I think what the prosecution can really do in closing argument is say, yes, we agree. The one thing we agree with Eric Nelson on is you should use your common sense. And here, common sense is aligned with emotion, it's aligned with the facts, and it's aligned with science. That Derek Chauvin killed George Floyd, and a murder conviction should happen because he intended to use the force that caused substantial bodily harm, which is what you need for a felony murder based on third-degree assault. And that's what we have here.
And today, Judge Peter Cahill told jurors to pack their bags because when they return on Monday, they will be sequestered. Take us into, if you can, the mind of a potential juror in that deliberation room. What happens? What does that process look like?
Boy, as trial lawyers, we would love to know that. I have never sat for a jury. I've tried, but it seems like I'm always conflicted out when I get called.
What do you think might happen?
Really what you're looking at is a jury that's going to pay careful attention to the evidence that was introduced at trial, just as they said in voir dire. And I was really impressed by the jury here in Minneapolis in terms of they all promised that they would not allow any outside influences. And of course, this trial is monumental for the outside influences that we have millions of people across America marching in the streets to demand justice for George Floyd. All those jurors have said, we're going to set that aside. We're going to look at the evidence that was introduced here in trial. And if those jurors keep their focus on what was introduced at trial, I think that they will come to a verdict. I mean, maybe not quickly, but I don't think we're going to be waiting a week for them to do so, because I agree. It just seems pretty clear that the prosecution won the day with their case.
All right. Civil rights attorney Jim DeSimone, thank you for your time. We surely appreciate it. Well, another Minnesota family demanding just for a gun. More on